Welcome to the Knowledge Buffet, brought to you by the Hunter Burnick Entrepreneurship Center. Today we welcome John Orange, who is a master mentor of intellectual property. Welcome, John.
My pleasure to be here.
What is intellectual property and why is it important?
Well, anything that you have created is your intellectual property. And it's very important in modern business because most of the companies, people like Google and Amazon, their assets are essentially their intellectual property. So for any business that is starting or wants to grow, intellectual property is the key asset that they have.
What is the difference between a patent and a trademark?
Well, intellectual property is made up of a number of subsets. So patents and trademarks are the ones that people know. Copyright and industrial designs are other types of intellectual property, as is confidential information. So a patent covers something that works, a composition, a piece of mechanism, a way of doing things. And so it's a concept that is put into practice and used for manufacturing. A trademark is your brand. And we all know lots of those, the Nike swoosh, McDonald's M, they are trademarks. And they protect different things.
How much does a patent or trademark cost?
Well, it's a little bit like asking how long is a piece of string, because it depends upon what it is you're doing. But generally speaking, you should expect a patent to cost you not less than $5,000, and a trademark would cost you in the order of $1,500 if you went to a professional to do it.
What makes a good trademark?
A good trademark is one that is purely an invented word or logo. It doesn't have any meaning in any language and has no relationship to the goods or the services that you're providing. That is the perfect trademark.
How do I use my trademark to keep it strong?
The main point is to use it consistently. You decide what your trademark is. You decide what colors it's going to be. If it's a logo, you decide whether it's capital letters or lowercase letters. You choose your brand, your trademark, and then you use it consistently. If you start to adapt it to other situations, you're weakening your trademark.
What happens if someone starts to use my trademark?
Well, ultimately, you end up in court. But of course, there's a lot of stages to go through before you get to that. First thing to do is find out how long this other person has been using the trademark to make sure they haven't been using it longer than you have, in which case you may be the one that is infringing their rights. But ideally, you would be the first person using it. If they are in the same line of business, you write a pleasant letter asking them to stop. If they don't stop, then it moves up, and ultimately you would end up in court.
How can I see if my idea is new?
Here we're talking more about patents, and patents can be searched. And there are online databases that are maintained by the US Patent Office and Canadian Patent Office, as well as the European Patent Office. And all patents are classified according to their technology, just like you have a library book is classified according to its subject. And so you can look in that class, you can search that class and see what has been proposed in that area, right from 1796 in the case of the US. They're all available for you to look at. And so you can look through there and see what else has been done in that area and why yours is different.
The big question, can you patent software?
Yes, you can. It's a bit of a misconception that you can't patent software, but in fact you can. And one of my major clients was in the field of mathematics, and we had 1,000 inventions relating to data encryption, which was pure mathematics. So it was software related. And now with artificial intelligence, you can patent the application of artificial intelligence to different situations as well.
I want to tell people about my idea. Can I do that?
Again, ideally, no, not until you've got it protected in one way or another. You should consult a professional first before telling the world about it. But if you have to talk to people, venture capitalists will want to know what it is they're lending you money for, then you can talk to them, but you should be sure that they know that it's a confidential discussion and you should have a non-disclosure agreement. But if you go to the market, you should file your patent application first before telling the world about it.
I've hired people to help me. How do I make sure that I own the intellectual property?
Well, if you hire anybody as an employee or even as a contract, you should make sure that the contract has a provision in that they agree that all rights to any intellectual property belong to the company, and that they will assign any rights that they have to you as they do the work.
And here's a fun bonus question. Will the protection I get in Canada protect me in the United States?
No, each country in the world is separate. So if you want in Canada, you need a Canadian patent or trademark or industrial design. In the States, you need a US patent, design, etc. And the same around the world. And there are techniques for making life a little bit easier to get protection in many countries. But basically, if you want protection, you go to that country.
Thank you for joining me on the Knowledge Buffet today, John.
My pleasure. I hope it's helpful.
We are going to take these little nuggets of knowledge a la carte, and we'll see you next time.